Hi, good evening to you all. So today we are going to discuss about the law of contract in our business law lesson. First, we'll get to know about the definition of the business contracts, right? What sort of contracts are existing in the world, right? So here we are going to discuss about the contracts like the business related contracts, right? So as a definition, we can say contract is an agreement between the parties which is to create a legal obligation, a duty enforceable by the law. So it's clear now here, a contract is an agreement between the two or more parties, right? So two parties or the more parties are involved and they are having the sort of mutual agreements between them, which is legally enforceable by the law of courts, or let's say the court of law. So when it comes to the agreements, the business agreements especially, we do business agreements based on the business affairs. And we are discussing the business, the parties, the consents and, some of the terms and conditions pertaining to with the type of the business contract. So the law of contract, it is a must to know about the law of contract as well, right? There's a law of contract which is the governing rule of this contract, all the contracts and agreements between the parties. So the law of contract can be defined as a contract is a legally binding agreement that recognizes and governs the rights and duties of the parties to the agreement, which shows you there's a legal governance for it. And also, a contract is legally enforceable because it meets the requirements and the approval of the law. It gives the approval by the law. So all the terms and agreements must be enforceable by the law in the sense that says all the agreement terms and conditions are legal. Can be in some circumstances, can be not ethical, but of course those are legal. So because of that, you can come into the contracts. An agreement typically involves the exchange of goods. Because why? I've mentioned you, because we are here going to discuss about the business types of contracts, right? So we are referring to the exchange of goods, services, money, or promise of any of those. Right. So we'll move further. So there are basic assumptions in generating these types of contracts. The first one is, shall be a freedom of contract to the contracting parties. Now, you cannot ask any party who's not going to, like, let's say, these are not mutual agreements between your friends, right? This should be the contracts or the agreements between parties in the field of business, right? If you are having sort of a terms and conditions between you and one of your friends to have a sort of a business deal, so we can call that as an agreement, or let's say we can call that as a contract, right? Fine. So the other party which you are going to agree with should agree with you or should come into you with you to attain to a contract with his fullest consent. That is what we call as freedom. You cannot, let's say, you cannot pay undue influences. You cannot pay what you call duress, right? Through these things, you cannot get someone involved into your contract. So there should be a freedom. Right, that is the first assumption. And the second assumption is expectations created by the promise of the parties shall be fulfilled, and then in the case of non-fulfillment, they can go for the court of law by making any sort of saying that a dispute, right? We call it as a dispute. When a contractual, let's say there are two parties involved in this contract or more parties can be. So whenever the party has breached a sort of a term or a condition in your agreement, so you can go for a dispute. That is, which means that you can sort your matters at the court of law, right? So those are the two basic assumptions in creating contracts, right? So we'll move to the nature of the contract. So when it comes to the nature of contracts, we can see the legal contracts are essentially include two types of things. First one is an agreement. Second one is the legal obligation. Of course, we discussed about the legal obligations. Now, when it comes to the contracts, or let's say when it comes to the agreements between the parties, There are two characteristics which we should consider. The first one is a plurality of the persons. Now let's say, as an example, you cannot come into a contract with yourself. Of course, I know that you have some sort of humanistic, or let's say some of mythical contracts with you, right? If I like whenever you are studying, right? Those are not business contracts, of course. Now, whenever you are studying, you think about after completion of this lesson, I will eat a chocolate, right? That is not a business deal, right? That is not a business agreement. So you have your own this thing. But anyway, when it comes to the business agreements between two or more parties, there should be two or more parties. So that is what we call as plurality of persons, right? Second one is consensus ad idem. So that is a Latin phrase. Don't be careful whenever you are using all these Latin phrases, right? Uh, Consensus of ad idem says that you must have to get the two-party consent to come into an agreement or come into a contract. Without having the consent of the other party, you cannot bind by the law to a contract. Let's say if somebody asks you to sign this, you should not sign that because you don't have the consent to sign it, right? You don't have the consent or assent, we say. You don't have the assent to come into that particular agreement because you are not likely to do that particular, you are not like to do that particular some of the conducts which are included in the terms and conditions. So you don't want to come into that sort of an agreement, right? So that basic consensus ad idem should be there in the agreement, right? We'll move further. So there are types of agreements where you can use, right? There can be so many agreements. There are basically three ways of conducting agreements. But of course, here in business, we just think about the agreements. Those are in writing. So we call them as written agreements because there's no proof to tell us. Like, let's say, if you have agreed with a party to conduct a contract. So in the case of dispute, let's say one party has breached one of the terms and conditions of your contract and you might have to go with the court of law to resolve it. So in that case, you cannot prove in the court of law whatever the words that you got that from that party whenever you are agreeing to that particular agreement, right? You must be having a legal document to prove that someone has agreed with these types of terms and conditions. So because of that, in business contracts, we are going with the written type of contracts. But of course, let's say, not in basically the business contract, but of course, you must remember one thing. If the court says, let's say, in a dispute, in a trade dispute even, you can see one of these three elements will be get into the consideration by the court of law in a sort of a breach of contract. Let's say, as an example, when it comes to oral way of creating contracts, right? Khata vashanayan karna contracts, we say. So as an example, you will agree with some other person to conduct a oral, like, let's say, a contract, to do some activity, but it's orally, right? You both have agreed. If there wasn't any other party, despite, let's say, other than you, so there's no proof to say that you have been agreed with that party to conduct the agreement, right? So that is the dangerous part of it, oral agreements, right? Anyone can make any breach over the contract, right? As I told you, the second one is written agreements. So we are going to discuss, right? And agreements by conduct. Let's say, not let's say merely if you want to get some consent. Let's say these are not business contracts, right? So while you are traveling by the bus, right, you will allow the other party to sleep over here, which means you will, by your conduct, that is what you call by agreements by conduct, right? You will allow him or her to sleep here. So which means you doesn't, like, basically you don't have any what do you call oral or written contracts. But of course, even you haven't given your fullest consent, but still you're implying it by your conduct. right? You have not expressed it. You didn't ask him to sleep on my what do you call arm, right? But still, you have given a sort of implication, like let's say implied that to that's fine, you sleep here. So that is, you accepted that by the conduct. That is what you call agreement by conduct, right? That is a simple example, but you don't want to, go in depth, because we are not going to do the business contracts by the conduct, right? Fine. So the recommendation of, out of these three concepts, out of these three types of contracts, my recommendation is to go with the written contracts. Otherwise, you cannot prove your terms and conditions in the court of law in a case of dispute. Okay. So we'll move further. Am I in a serious mood? Fine. So because the subject is very serious, huh? Fine. Okay. Essential elements for valid contract is our next subtopic, right? So anyway, I know most of you are, enjoying yourself in this Corona vacation. I know you don't want to hear these types of stuffs, right? Fine. Okay, there are basic elements in valid contracts. To become a valid contract, a contract should have to have these types of things included in that particular contract. So I'll tell you the list first, and we'll discuss all these things in our next lessons as well. The first one is offer and acceptance. Intention, that is what we call as a legal intention, and legal intention to create the legal bounds. And lawful consideration, capacity of the parties. Wow, capacity of the parties, right? So you must be a giant to come into the agreements, it seems. No, not that, right? That is what we call as a legal age, right? And the nature of your conduct, let's say, you should not be insane like that. And the free consent, I told you, without your, with a sort of undue influence or duress, no one can have your consent. You must be giving your consent with your full assent, right? And lawful object should be there to make a sort of a contract, right? You cannot make any contracts on a life of a person, right? Okay, right. Lawful object. And writing and registrations. And possibility of performance. There should be a possible performances, right? You cannot expect the things that, as it was in asterisks, you cannot expect the persons to do whatever the things which can be performed by the gods, right? That's fine. So not expressly declared, it's void. If something is not expressed in the contract, it can be void. But of course, there are some contracts terms and conditions called express terms and implied terms. We are going to know about all these things. Fine. Then moving to these types of contracts based on the facet of the legal enforceability. How can the legal facet can enforce over these agreements, right? There are basically 5 types of agreements. We can call them as valid contract, voidable contract, void contract, unenforceable contract, as well as the illegal or unlawful contract. So we'll get to know about them. So what do you mean by valid contract? Don't be afraid of, like, let's say, in your whatever the things that I've mentioned earlier, the offer and acceptance, all these things will be discussed later, right? So with the facet of the legal enforceability, we can see the first one is a valid contract. Valid contract is, of course, you can have between the parties. That is valid in the sense the agreement which can be enforced by the law of that particular country. So it's a valid contract, right? You can perform. But when it comes to voidable contract, these are not void contracts, right? These are voidable contracts, where either party has made a sort of term or a condition which cannot be enforceable by the law, right? Where you haven't agreed with yet, but still, because of that term or a condition, it is voidable. Let's say, as an example, if you are going to have an agreement between a party, so once you made an offer, let's say, these are my terms and conditions, will you be able to agree with me? This is the question you will ask, right? So in that circumstance, if that party says no, because of this contract, what do you call this term or a condition, I cannot agree with you, in the sense that is a voidable contract, because you cannot conduct that contract for the years, whatever you are expecting, right? For further. So because of that, we say that is a voidable contract, a cancelable contract, right? Which is not going to be worked with the legal facet of laws. Then the void contract. Void contract in the sense, agreements which cannot be enforced by the law. Agreements which cannot be enforced, in the sense you cannot, because basically those can be illegal. Now, as an example, if a person asks you to transport grams of heroin, you cannot come into an agreement because it cannot be enforceable by the law, right? It's an illegal activity, so the contract is totally void, right? And the contracts which are cancelled by the court of law because of the invalidity of some of the terms and conditions, or the illegality of the terms and conditions, we can call them as a void contract, which is not going to be at the existence. Then the fourth one is unenforceable contract. So unenforceable in the sense, it says that is not enforceable by the court of law to conduct. Can be illegal, can be there are some sort of mismatchments between the agreements, right? So because of that, those are unenforceable and illegal or unlawful, which cannot be even drafted, right? You are asking to conduct an illegal matter, to conduct an illegal obligation. So because of that, they may come as the illegal or unlawful contracts. Fine. So we discuss about the facet of the legal enforceability. Then the next one is all about mode of creation. Based on the way that is created, you can categorize or classify the types of contracts, right? So the first one is express contract, where all your the terms and conditions are mentioned in that particular contract. Let's say, what are the obligations by you being the first party? What are the contracts? What are the obligations that you have to other party? That is mentioned. And being the second party, or being the next party, the other party, that party's duties and responsibilities are mentioned in the contract. So other than that, you won't be bound for any other legal, the obligations to the either party, right? So all these things are expressed, right? Written or mentioned. Those are called as the express contracts. And there are some contracts called implied contracts. Let's say, take an example of, simple example. Think about a bottle which is half filled by the water. So whatever the things I can see is it is half filled by the water, right? But someone can say it is half empty of the bottle. The half of the bottle is empty. So that is what we implied. And the previous one was whatever the things that we expressed in our contract. So by, let's say, expressing a contract should not allow another thing to be implied in the contract, right? Be careful with drafting contracts, because anyway, if you are drafting a contract, being a business personality, being entrepreneurs, being business managers, you must get the consultancy of the legal officers in drafting the contracts. Be careful. If you are pretty sure about it, yes, you can. Right? If you know the format of the legal, the document and all, so you can do. But of course, don't do it as you want, because you will imply something through the contract, right? Okay. So especially these things are happening to the HR managers while they are preparing their letter of appointments, letter of extension of contracts, and things like that. Finish. Okay. So be careful. And the third one is a constructive contract. Okay, fine. Just give me about 5 minutes, so I'll conclude this session, right? Constructive or the quasi contracts. So, which can be the misnomers, basically the misnomers, in the sense that if somebody hasn't a contract between two or more parties, let's say, so you might have to, now in the case of a dispute, you might have to go for the courts. Let's say you have sold a good just because of the word, And then finally, you basically you think like a circumstance where you don't have a contract, but of course you have sold some of the commodity to one of your friends, and he's already been agreed to give you a sum of money, but you haven't received it. Okay, forget about your friendship. You must have received the money now. Fine. So that is why I'm telling you not to go with the contracts with your friends, right? It won't be work. So then you will go for the courts, and you don't have an agreement to prove that this person has bought it from you. Bought in the sense that one has bought it from you with the purpose of, let's say, with an intention of buying it. But ultimately, it's proven that someone, the person is there in the courts, has, let's say, brought it from you, right? It's proven. But still, the court of law is having the right to give you an order to recover the, let's say, the cost of that particular product through these types of constructive or the quasi contracts. So let's say, basically a misnomer created by the court of law, no official agreement exists between the parties in disputes over the payments of good or service. So the court of law will decide on the terms and conditions which you should agree with the other party, and the payment terms and things like that to recover the cost. That is determined by the court of law. You don't have any that will be decided by the lawyers and the regulatory personalities, right? So those are the constructive or the quasi contracts. And then types of contracts with the mode of creation, there are other two types of. The first one is the executed contracts, and the second one is the executory contracts, right? Let's say once you agreed, let's say as an example, whenever you are purchasing a car, you will agree with your leasing company to make installments in monthly basis. So in that case, let's say if you make your first payment, let's say if you made your first payment, once after you made your first payment, that is what we call as executed contract, right? Executed one, in the sense you made the payment, and in the sense your conduct says that you executed it, right? But executory in the sense before you execute it, in the sense you agreed but you have not yet executed, right? Those are the two types of altogether there are five. Here one of the two called executed contracts as well as executory contracts, right? So I know you are not with an interest to be here. So thank you very much for attending today's session. I hope that you got some of the ideas about the laws of contracts, and this is not the end of the laws of contracts. We will be having the next session as well, because we are going some sort of in-depth information during our next session. Sorry, I was at a very serious mood because teaching law is very crucial, because why it is very dangerous, because some of the ones I release this into after my live cast, once I released this into the YouTube. So I'm talking about the legislative rules and regulatory backgrounds, right? It's, even if I'm making any mistakes, so I'm finished. So because of that, I must be aware about all these things, and that is why I'm in a very serious mood, and I can't make any sort of statements which as I want, right? All these are regulatory things, and some of the legal personalities can sue me, revealing some of the false information, right? So every information that I've told here is correct and true. So you can refer more information on my websites as well, and some of the information are uploaded in my students' websites as well. So you can refer them as well. And if you have any clarification, just contact me through my mail so I can give you the descriptive explanations, as well as if you want my contact numbers and my things are mentioned there, so you can contact me and get to know things. And of course, to get the validity, you to prove the validity of all my statements, you can consult your lawyer and see if there's anything. So let me know. So thank you very much. I was very pleasure to have this evening, and I'm going to conclude my session. So thank you very much for being on time with my live sessions. If you have any concerns, just inbox me, and also you can comment in my video. Thank you very much.